Africa, this is a comparative note addressing those key lessons that we can learn from the practices with regard to PIL. I'll start with a quote from Justice Rugachingira. He says, given all these and other circumstances, if there should spring up a public-spirited individual and seek the court's intervention against legislation or actions that pervert the Constitution, the court, as guardian and trustee of the Constitution and what it stands for, is under an obligation to rise up to the occasion and grant him such standing. As has been described, PIL is the name given to efforts to provide legal representation to previously unrepresented and underrepresented groups and interests. Such efforts undertaken in recognition that the ordinary marketplace for legal services fails to provide adequate services to significant segments of the population and on behalf of specific, or as you could say, significant interests. So this concept may not be so eye-catching. This concept may not be so eye-catching or revered, given that day-to-day economic instabilities demand that many times the lawyer or the public interest litigator may need to seek for daily bread. Nonetheless, public interest litigation explores dimensions where quality justice can be found without necessitating the need for an inordinate cost. By this we mean that you will have situations whereby PIL is not something that you are going to benefit financially from, but it is so critical that in the absence of the same, a lot of damage can happen or continues to happen. So public interest litigation, therefore, has been argued to jumpstart enforcement from state bodies, while at the same time exposing tight segments in the law and failures of the same. So this paper, therefore, is going to do some kind of comparison, taking note of those unique situations, focusing on political and economic connotations in cases involving public interest litigation, drawing examples from more developed judicial arenas on the continent. It addresses key lessons and practices to be learned from these champions in public interest litigation. It has been also suggested that public interest litigation presents a strategic opportunity to engage the judiciary on societal issues. The fabric around the law on PIL is structured in a manner so as to prevent and to protect courts from being used as playground by litigators or litigants, meddlesome interlopers, and other cranks who have no real stake or interest in the subject matter of the litigation they are interested in. And I think we saw an example of this to an extent regarding the case by Male Mabilizi against MTN. So courts have gone on to view PIL in the context of what the rule of law would ideally envision, stating that the best way to ensure observance of the law is by permitting any person to put the judiciary machine in motion, whereby the citizen could bring an action in respect of a public derelict, rendering certain requirements such as locus standi in certain cases unnecessary. By locus standi, we mean having, like in the case of Male Mabilizi, you have locus, you have a specific, can you prove that you have a specific interest? You know, you have standing, you have, can you show that this matter really affects you to an extent. So we shall delve into these legalese around PIL in Uganda and the selected jurisdiction. In Uganda, one of the earliest notions of PIL, in my view, is the case of Uganda versus Commissioner of Prisons, ex parte Matovu. The case, though largely setting the pace for the application of the PQD in future decisions, that is the political question decision, also involved a question concerning the liberty of citizens. It was one petition that on its face was littered with technical errors and clear lack of oversight in the drafting of its pleadings, that on an ordinary court day would warrant its dismissal. The court at that time, however, took quite an unpredictable view in its wording, stating, and I quote, "On further reflection, however, bearing in mind the fact that the application as presented was not objected to by counsel who had appeared for the state, and that the liberty of a citizen of Uganda was involved, and that considerable importance was attached to the questions of law under reference, since they involved the interpretation of the Constitution of Uganda, we decided, in the interests of justice, to jettison formalism to the winds and to overlook the several deficiencies in the application, and thereupon proceeded to the determination of the issues referred to us." Close quote. So, while not directly a case involving PIL or public interest litigation, it compounded an important principle of jettisoning formalism, a concept that would become manifestly important in Uganda's struggle to push public interest litigation in light of the common law doctrine of locus standi. While the petition was defeated, Professor Onyango, as cited by Justice Chivita, said that it set the ground for Uganda's gradual movement away from the swift dismissal of significant constitutional cases on flimsy technical ground. More importantly, the mantra jettisoning formalism continued to crop up in subsequent judicial decisions, especially those of a political nature. So what then is the enabling law on PIL in Uganda? We've already talked about Article 52. You can talk about Article 1373, and I think to an extent, my senior colleague, Dr. Zahara Nampeo, has helped elaborate on this, and I don't know whether I should go the distance of reinstating. But for the avoidance of doubt, the spirit of PIL is also extended under Article 137, sub-Article 3, that makes provision for any person that alleges a violation accruing from an act of parliament or any law or anything done under the authority of any law, acts, or omissions by private persons or authorities that contravene the Constitution, to place a petition to the Constitutional Court. This right is not limited to only persons that have suffered injury, but constitutional mandate under Article 34 imposed on every Ugandan to defend the Constitution. While the position previously was that there was no law in place for the enforcement of rights under Article 50, courts have construed this provision in light of Article 274 that preserves existing law subject to modifications so as to bring them in line with the 1995 Constitution. But apart from the Constitution, we now have laws such as the National Environmental Act of 2019, the Human Rights Enforcement Act 2019, which reinforce Article 50 of the Constitution. We can also talk about the fundamental human rights enforcement procedure, among other things. Some cases have been cited by my colleagues, and I just want to reiterate that it's important to note that previously litigants proceeded under Article 1371 of the Constitution, and they faced considerable difficulties accessing courts had it not been for the decision in FIDA versus the Attorney General, which involved the challenge of several sections of the Divorce Act. In that case, the petitioners sought a declaration from court invalidating those sections, and issue arose as to the constitutionality of Rule 4 of Legal Notice Number 4 of 1996. That rule was to the effect that only 30 days room is given after the enactment of what is perceived as an unconstitutional law. Now, the court ruled, to the extent that Rule 4.1 of Legal Notice 4 of 1996 imposes restriction to the right of access to the Constitutional Court, which the Constitution itself does not provide for. It is seeking to add to or vary the Constitution and therefore to amend it without doing so through the amendment provisions of the Constitution. It is clearly against the
it is now high time that this court restored in full the citizens' right to access the Constitutional Court by declaring that the rule is in conflict with the Constitution and
null and void. These decisions were crucial in laying fertile ground for the development and growth of bill in the country. During her introduction, Dr. Zahara was introduced as one of the subjects of PIL or PIL, and it reminded me of two scenarios, especially in regard to this case. One is when the journalist, Uganda Journalist Safety Commission, sought to try and find certain sections of the Sedition Act unconstitutional. And I think they fell foul of this section. And I remember then Justice retired Justice of the Court of Appeal and Constitutional Court, who just recently retired. His name has slipped my mind. The one who wrote the dissenting decision in the presidential petition that has just been decided. What is his name? The Court of Appeal. Could someone remind me? His name starts with letter K. Kakuru, yes. I remember he was the lawyer for the Uganda Journalist Safety Commission. By that time, my own brother was one of the petitioners, and I remember they were condemned in court when that case was dismissed. We are grateful that the Attorney General has never sought in that regard. Let's look at the forum. What does Article 50 mean by a competent court? Article 50 enjoins persons with claims under this provision to apply to a court of competent jurisdiction. The Human Rights Enforcement Act, on the other hand, also goes ahead to specify the forums for redress under Section 4 of that Act, as the High Court having mandate to hear any application relating to enforcement or violation of the non-derogable rights and freedoms in Article 44 of the Constitution. Now, we've talked about the question, locus standi. But maybe let me just say that the Act also makes provision for jurisdiction for the magistrates' courts to handle specific scenarios, excluding those set out in Section 4 of the Act. These developments come in against a gap in the law that previously created confusion as to whether a cause under Article 50 would fail. The court previously had bore the daunting task, stepping out of their way to make orders where the law was inadequate. With regard to locus standi, Diane Haskett poses the argument that resort to court as a forum for airing policy issues has been traditionally curtailed by the judicial self-restraint. in the exercise of which the standing of prospective litigants has been examined as a threshold inquiry in the determination of the appropriateness of judicial intervention. With courts placing strict emphasis on compliance with the issue of locus standi, stating its centrality in action, you find that their objections of this manner have also been an issue all too common in public interest litigation. However, courts have been taking and are increasingly taking a rather unwelcoming stance to them. In the case of Charles Harry Touadera versus the Attorney General, the court emphasized that the question of locus was not an issue in Bill. The Nigerian Supreme Court in Fawehimi versus Akilu gives a particular interpretation of the question of locus standi, stating, and I quote, "It is a universal concept that all human beings are brothers and assets to one another, especially in this country where the socio-cultural concept of family includes nuclear or extended family that transcends all barriers." This relatively contextualized interpretation of the law, in line with the societal fibers of family and society, has not yet made its way to an extent in Ugandan courts, and that have often considered a legalistic approach towards such questions. It's no surprise that the same objection continue to prevail despite the permissive language in the constitution law. It's no wonder, for example, in versus MTN, this case was kicked out. Let's look at Peel in Nigeria and maybe draw lessons from there. The issues above are some of the dimensions through which courts and litigants have approached the whole notion of Peel in Uganda. The trend in the East African nation is to the same extent a reflection of the broader issues affecting other common law jurisdictions in Africa. A comparison can be drawn from Nigeria. Nigeria, like Uganda, is a former British colony, gained independence in 1960, 2 years before Uganda. From then on, it was downward spiral with convoluted conflict and struggles for power between armed generals along mainly ethnic lines. In 1999, Nigeria returned to civilian rule under a military-dominated constitutional transition. This violent heritage is one factor that should have ideally entrenched and groomed the whole concept of Peel in Nigeria, given the numerous human rights violations and constitutional crises the country faced in its earlier years. The enabling law and practice in Nigeria. So Nigeria continued to struggle. There was no constitutional protection of human rights for a while, and even with the inclusion of a Bill of Rights in the Constitution, there was little achieved following the early violent years of independence. It was not until the emergence of one proponent, Chief Gani Fawehimi, as an icon of Peel in Nigeria, that Peel actually started to take off. For a while, Peel operated along several without direct governing rules or practices. Thus, many petitions were ousted on grounds of lack of locus standi, or on the basis of a perceived fear of a floodgate scenario. During this time, a few decisions stood out. They depicted the fact that courts had taken notice of the growing violations when left unchecked due to lack of judicial intervention. Thus, in the case of Mam and Lawyers Alert versus Chairman Benue State, INEC, the court recognized the locus standi of a non-government organization in actions on behalf of persons challenging suspension of local government elections. It's against these inefficiencies and inadequacies in the law relating to public interest litigation that pressure to reform grew. This reform finally came in 2009 with the promulgation of the Fundamental Rights Enforcement Procedure Rules 2009, where under Article 3E, courts were under the obligation to encourage and welcome appeal in the human rights field. The provision also discourages the dismissal of human rights related appeal on grounds of lack of local standard. The provision also places legal practitioners, NGOs, human rights activists, and groups under a duty to be vigilant in terms of instituting actions on behalf of any potential applicant. Thus, this new position in the law crystallized the findings of the Supreme Court of Nigeria in Fewehimi versus Akilu that birthed the philosophy in appeal that all human beings are brothers and assets of one another. Furthermore, in the case of Chief Gani Fawehimi versus the Federal Republic of Nigeria, court continued to emphasize the judicial function in light of questions of appeal by stating, and I quote, "Judicial function must primarily aim at preserving legal order by confining legislative and executive arms within their powers in the interest of the public, and since the dominant objective of the rule of law is to ensure observance of the law, it can best be achieved by permitting any person to put to the judiciary machinery in motion in Nigeria, whereby any citizen can bring an action in respect of a public derelict. That's the requirement of local standard. You can't will merely impede judicial. Say at this point that it seems Uganda picked from this provision when it passed the anti-torture legislation. Before then, it is he who has suffered a public wrong or gross violation of their rights that is the primary source. But in the Anti-Torture Act, it was envisaged that people who have been tortured may most likely withdraw under pressure. And so the provision was made in the Anti-Torture Act that you could actually take on a matter regarding torture even if you were not the primary recipient in quotation of the torture. And for those of you who remember Netfield and a few others, including myself, we were in Makindye at the time that the court was surrounded by human beings who were threatening violence. But that is something we need to discuss later. So this amendment of the law seemed to reconcile the law with the practice, effectively rendering objections along the lines of lack of local standard nugatory. Let's look at appeal in South Africa. Considerably, South Africa had the faster growth of appeal, with judgments dating as far back as 1910. As time went on, cases in South Africa involving appeal were mainly centered around anti-apartheid settlements or sentiment. And I think His Lordship, Justice Chivita, has given us an amazing example of such a scenario, where you assume it's only the blacks who think they are under a violation, but also the whites in that example also feel stressed by apartheid. The conditions surrounding the development of appeal in South Africa were central in informing the nature of public interest litigation in South Africa, and this gave it an edge over other countries. Given the fact that it was not simply used as a tool to address issues of human rights violations, but it was also very important as a tool of driving socio-economic and political change. In the earlier years prior to 1994, as you know, 1994 was the day or the year when South Africa, under Nelson Mandela, finally was being ruled under majority rule. Courts required a sufficient, direct, and personal interest in that matter prior to 1994. During this period, a number of laws that existed and favored the state and the judiciary followed the letter of the law, even though it may have taken the view that the laws were unjust. A shift occurred. By this I mean that the judiciary took on the view that the law is the law, black letter law, and the interpretation was literal. A shift occurred in 1994, however, when a Supreme Constitution and Bill of Rights were enacted alongside the creation of a liberal constitutional court. This would ultimately turn the tide for appeal in South Africa. The new constitution made provisions for structures that would foster effective public interest litigation. These structures included extensive fundamental human rights that were not limited to civil and political rights, but extended to economic, social, and cultural rights. And I know that Dr. Zahara has done us a lot of good by helping us appreciate the difference between civil rights and why the two are given the same level of appreciation. South Africa graduated through several phases in its toil to perfect PIL. A dearth of jurisprudence around the whole concept was remedied by teaching PIL in law schools across the country. This move was largely aimed at ensuring that future generations had an assurance that their livelihood would be secured, not just by the state, but by members of the public as well. This greatly influenced the nature and scope of PIL in South Africa. Aside from what you would consider constitutional guarantees that effectively dislodged the locus standi objection, activism swept across the country, realizing that past injustices could not and should never be repeated when the power is in the hands of the people. In due course, a fully fledged public interest litigation culture had been developed in South Africa. While the whole concept had considerably picked up, South Africa continued to struggle with issues of funding, a shortage of experienced and skilled staff, amongst other things. These are issues that will not stop today or tomorrow, let alone with continued pressure on the state to provide funding, given the fact that governments are constantly hampered in executing their official duties. And I think the conversation on progressive realization that we had earlier comes into play at this point in time. While South Africa has had considerable achievement in the context of enabling PIL, courts have gone ahead to make rulings entitling public interest litigation or litigators to costs from the state as a way of encouraging PIL, setting an objective approach in cases involving PIL, avoiding slapping costs on public interest litigators unnecessarily. The case of the trustee for the time being of BioWatch Trust versus the Registrar of Genetic Resources and others is one clear example. This was an appeal prompted by two unfavorable decisions on costs made in respect of the petitioner, an environmental watchdog that sought information from government bodies with statutory responsibilities for overseeing genetic modifications of organic material. In previous cases, where it had been successful, no orders were made as to cost. To their displeasure, however, the petitioners filed this appeal. Court had this to say: courts should not use costs award to indicate their approval or disapproval of a specific work done by or on behalf of particular parties claiming their constitutional right. What matters is not the character of the litigation and their conduct in the pursuit of it. This means paying due regard to whether it has been undertaken to assert constitutional rights and whether there has been impropriety in the manner in which the litigation has been undertaken. So what lessons then can we pick? Is the need for dedicated public interest litigation appeal institutions can never be stressed enough. Successful rights revolution depend on as much on support structures for legal mobilization as they do on favorable constitutional conditions, a sympathetic judiciary, and public rights conscience. These organizations should ideally be driven by broad social and political strategy, informed by a proper philosophy. This eradicates the risk of having decisions from courts in a vacuum, and I think Justice Chivita said something about this. For example, Scott Cummings said the following, and I quote, "Judicial decrees without a political base are vulnerable to chronic non-compliance, public backlash, statutory reversal, or judicial retrenchment. In many contexts, courts lack the necessary expertise, legitimacy, and enforcement resources to secure lasting change. And in other contexts involving fundamental rights, public interest organizations lack the resources to represent more than a small fraction of deserving claims." And I think a conversation was had earlier whereby I think Dr. Nampel asked, how can we better prepare? And Justice Chivita said, prepare as much as possible. And you know, even with just this simple preparation, just photocopying costs alone can be quite exorbitant. So we need those institutions. The creation of an organized platform like NetPIL, PILAC, and others with a refined and synthesized agenda and philosophy that envisions more than mere litigation is key in ensuring that PIL in Uganda is used as a tool of social and economic and political change. This speaks to the quality and depth of PIL. PIL should not come up as a question of convenience, rather it should be a question of necessity. The need to see a difference. In other words, it simply isn't enough to have an umbrella of PIL litigators if they act in no particular context. The second thing that we can talk about is research. Badlander on public interest litigation in South Africa argued that one considerable lesson of great importance to the body of PIL relates to how practitioners can harness the power of routine casework in the field. This enables public interest litigators to identify important issues for litigation, identifying appropriate clients, among other things. This can foster effective legal activity and the building of community and institutional links. I will not say much about research. I think we cannot emphasize that enough. Then we can talk about specific goals and measures of progress. PIL lawyers ought to identify the objectives and priorities for PIL. In doing so, they can properly select projects that can advance the particular objective. So, in essence, lessons learned are, can we have specific goals? Can we measure progress? Can we organize ourselves? Can we strategize between NetPIL, PILAC, UCLF, and those other interested organizations so that what we are doing is given the maximum support it deserves, and in so doing we can achieve at least one success at a time. Then the other thing we can take as a lesson is harnessing the power from pro bono initiatives. Pro bono, or free legal services, or legal services at a reduced rate, rely on several tools for efficient operation. These include volunteer attorneys or lawyers, the public service, law student organizations that promote pro bono service in order to allocate resources, etc. Pro bono service, as depicted, by Anne is a response to the narrative of lawyers as servants of greed and power. It is aimed at the issue of unequal access to legal help. The collaboration of peer litigators with pro bono service providers from the private sector can help incorporate invaluable experience and expertise in the entire appeal process. This also speaks to the quality of public interest litigation. Bringing minds from private practice into issues of appeal helps create a significant contribution for the social good. I must emphasize that public lawyers or lawyers in public service, attorneys, are part of this process. And I'll explain why. There was a case which involved the prosecution of the late governor of one of the banks, Greenland Bank. And I remember now chairperson of the Electoral Commission was a prosecutor at that time. I think he was deputy prosecutor. And he brought to court the issue that more than 3 magistrates had listened to that case and it was not permissible at that time. Because then who is going to pass judgment? I think now her Lordship Justice Catherine Bamgemerere was the first magistrate to hear that matter. When she left, another magistrate came, and Justice Jabaka Mamigeni was asking the question. We have a legal problem here. He could have kept quiet. After all, it was his case, and he would have received judgment. But state attorneys need to go beyond just a will to ensure that that justice is not only done, but it is seen to be done, and it is done properly. So we need state attorneys, and I would encourage NetPeer and UCLF and PILAC that when we have events such as this, we should continuously invite the DPP, we could continually ask the Attorney General to send representatives here. Now, this is an argument I made yesterday while speaking to a class when we were discussing the concept of corruption. And that conversation actually came after my appearance on Saturday on Capital Gang when we were talking about corruption and how we can resolve it. The lesson we should learn is that litigation on its own does not guarantee social change. For those of you who have been involved in these matters, I'm sure Zahara, you are aware of the case involving public of female genital mutilation amongst the Sabini people. A law is in place, the FGM Act, but FGM continues to happen. Justice Kibita talked about the Anti-Witchcraft Act and the litigation surrounding that. But witchcraft, for those who are really centered in this nation, you know that it happened or it's perceived to happen. Apostle Sapiri here is a preacher of the gospel. I'm sure he has been casting out so many, what are they called? Talisman and other things. And the point I'm making here is litigation on its own does not guarantee social change. Mekumi Susu has argued that one serious criticism of PIL is that it does not lead to reform of social institutions or practices. Drawing a scenario from the PIL South African case of the government of the Republic of South Africa versus Grootboom and others, Megumi highlights the fact that a court decision regarding members of the Grootboom Society that had been evicted, having settled on private property, fell short of providing any proper protection. The court only highlighted the fact that the respondent breached its constitutional mandate to prioritize housing for the vulnerable, still continued to live in the same squalid condition. This creates the narrative that perhaps PIL is a gamble with the state. In this context, lawyers ought to focus on practicing constructive PIL, a form of public interest litigation that utilizes mainstream political, economic, and social avenues to supplement judicial decrees to achieve a tangible form of justice, especially in the context of constitutional dispensation with inefficient judicial enforcement systems. And I think Justice Chivita, in a veiled attempt, suggested to us that maybe litigation may not necessarily achieve everything that we want, that sometimes litigation on its own may not be everything and anything that we are hoping for. This then reminds me of the 2016 case where we as lecturers at Makerere University were allowed as amici jury before the Supreme Court. And knowing full well that a remedy or a declaration of the court would not be sufficient enough, we applied for the structural interdicts that you have been mentioning here as a way to push the state to actually do something. And I think tomorrow or later on today, Mr. Robert Kirunda will be sharing his experiences as a litigator on behalf of others. So the point being made here is PIL on its own may not push for social change. We must seek for other interventions, including, I think, fronting certain people to become members of parliament. And the example we have here is when our own member of NetPIL, I choose to believe, and the School of Law's Refugee Law Project, the Honorable Dr. Zahara, what's his name? The one who has helped us in transitional justice. No, former employer, former MP Gulu on the DP ticket. And there's another one. Wasapili, don't you remember? Yes. It will come. Yes, Leandro Komakej. And he's been our champion for the National Legal Aid Policy, our champion for on the transitional justice front. The other lesson we can take is that big law firms have an opportunity to create social change and influence. Justice Chivita mentioned how he argued the case on behalf of the state to retain the death penalty. And the team, on the other hand, FHRI, was represented by Katende Sempebwa and company advocates. And they did quite a little, they did quite a lot of research, as he mentioned, and gave the state a run for its money. As corporate clients become increasingly willing to subsidize professional development opportunities for young associates and firms, become too highly leveraged to provide such opportunities to all who need them, pro bono representation fills an important gap. Large law firms are best positioned to engage in PIL through provision of pro bono service. The threat of large law firms increasingly becoming detached from the needs of the non-corporate world is real and well too common. However, through PIL, they are presented with an opportunity to become relevant in becoming tools of influence in areas that matter. This engagement also builds the firm's reputation and visibility in the community, at the same time improving its ranking. The quality of PIL and PIL matters. Lawyers ought to aspire to become more than a busybody or middle-thumb interloper with no real stake in the subject matter. Essentially, lawyers should build a litigation character in the context of PIL that is grounded in sound, objective, practical, and real interests. As examples from South Africa and Nigeria have shown us, interests that can yield and drive social change when presented before the court and the public need to be given that kind of priority. Not simply a dissenting voice, a far cry detached from any real objective, devoid of the power to make or incite change. In conclusion, therefore, public interest litigation is a powerful tool in the dynamics of state governance and policy implementation. A tool strong enough to mobilize the public in all shape and size to align their sentiments to a common justiciable objective. It is in this regard that the whole notion of PIL should be accorded greater emphasis and weight by practitioners. It should not be limited to the base conceptualization as a tool for the poor and vulnerable only. Rather, as the case of Malema Bilizi has shown us, as a sword to protect the public from selfish and callous actions, not only of individuals, but also of other institutions. Thank you very much.
All right. Thank you very much, Dr. Ruhweza. Ladies and gentlemen, another round of applause for Dr. Ruhweza. Very insightful thoughts on best trends and practices in the area of PIL. On our next session, we have a plenary, but it also happens to be time for lunch. I want to leave it to the room, participants in the room, to suggest whether we should do the plenary now or have lunch first. Dr. Reza seems to suggest now. Okay, we'll take a couple of questions and then we'll head for lunch. All right. Questions? People online, you are invited to weigh in. You can put up your hand and we'll be able to take your comment, remark, or question as the case may be. Doctor, is your hand up? All right, we'll start with you.
Thank you very much. There's a young lady here. She's a student. So she was wondering whether my hand is up. I think for them, they really put up and make sure that teacher sees the hand. Thank you very much, Dr. Ruhweza, for that presentation, very detailed about the trends, the lessons from elsewhere, Nigeria, South Africa. This really is something from of interest. Just thought about it as you are presenting. How are we faring? Have we, as NetPil, done some kind of a graph to map numbers and successes? Can we have an idea about how the involvement of PIL has gone in Uganda since as far back as Dr. Ruhweza, I mentioned the Experte Matovu? I would just like to have a quick overview of how we are doing in that field. And perhaps Dr. Ruhweza also, what has been what has made it for South Africa? They seem to have done a lot. Is it that the country is bigger and they have more litigators? Is it appreciation of the issues by their judicial mechanisms? What is it you think that could have been one of those factors that has helped South Africa to grow in this area? Any quick issues here? I'd be happy to share.
Thank you, Doctor. Any other question?
Thank you, Doctor, for the wonderful presentation. I just want to add, I think my question is somewhat similar to what Dr. Zahara has asked. In view of the comparison study and in the spirit of picking lessons from other jurisdictions. Mine is on the question of implementation, getting that change that we seek to find and actualizing it. What have other jurisdictions done different that has helped them get to that point? Because my general feeling is that in Uganda, even when we are trying to grow the PIL, whereas we are trying to do as much PIL as possible and we are bringing forward the issues that should be brought on the table, I feel like at the end of the day, we are simply getting recommendations and, not actually getting the results that we are looking for. So maybe we could learn a thing or two from other jurisdictions so that we can, run that extra mileage that we seem not to be getting.
All right. Thank you, Vero. I will also ask, my question is a little bit similar to what Dr. Vero have asked, but a bit different as well. It also stems from the discussions we had in the morning on the question of resources vis-a-vis politics. It has been mentioned since morning that it is dangerous for us to litigate in such a way that we are unable to balance the politics and the law, especially on the question of seemingly dipping our hands into the pockets of the state in the pursuit of these economic, social, and cultural rights. And my worry is that we put ourselves at the mercy of the state. I am one of those people who don't really believe countries, especially countries like Uganda, are really suffering from resource challenge. It's a question of priorities. I think the politics is directing our priorities differently, whereas we should be at a stage where we're moving into welfare. We are still politicking a lot, and I don't know. I want to think that it is then the role of the law, perhaps still as a tool to redirect the priorities of the state, and therefore I worry from what the judge recommended in the morning and some of the discussions that have come through, where we approach with caution the question of resources vis-a-vis the law and the litigation process. Yes, thank you.
Thank you very much. The first question by Dr. Zahara seems to be probably not directed to me, but to NetPeel as a whole. And I think as NetPeel, we need to find time and maybe some resources. I don't know whether Arthur is here or online to be able to do the kind of mapping that Dr. Zahara has suggested for us. I don't know whether there was a specific question for me to respond to, or have I got it right? Okay, thank you, Zahara. Now, my sister asks, what has helped South Africa? The trend that I noticed, and from my presentation, is that you see PIL picking up after South Africa got independent. By this I mean when black majority rule took over with a progressive constitution and a liberal constitutional court. I know when you say liberal constitutional court, there are some challenges there. Of course, some people may think that there is a dictatorship of the liberals as well. But it seems that change in the political climate of South Africa opened up the the public interest litigation culture, whereby both the state and the litigants were kind of speaking the same language. Remember, President Nelson Mandela, as he was then, had for most of his legal career done a lot of, public interest litigation representing, disadvantaged Black communities against the oppressive arm of the state. And I think it became easier then for the political will, the liberal court, to all align with the desire of making South Africa a better place for everyone. And you remember there was that mantra of a rainbow nation. I see the same with Uganda to an extent. When the likes of Mr. Philip Karugaba, who I personally think was one of the first people who opened my eyes to public interest litigation, when they were suing the state for disclosure of the documents regarding, I think, Bujagali and so on, with Justice Kenneth Kakuru, Uganda Journalist Safety Committee that I mentioned, among others. The 1995 Constitution, although it started with the hiccup of the 30-day rule that you can only bring a matter which has arisen after 30 days or within 30 days of the passing of a specific litigation. Apart from that hiccup, we've seen an increase in public interest litigation cases after 1995. Therefore, I think that political trend that you see in South Africa, that you also actually see in Kenya, has a huge impact on the quality of judges, the exposure of judges. The truth is, I think you asked the question to Justice Chivita. I think the more exposed a judge is to the rigors in the international, the more easy it is for that judge to agree with the litigation that is being brought before him or her. Just take a study of the kind of judgments written by the likes of Justice Lydia Mugambe, who's had exposure in Arusha and these other international fora. There's a tendency for them to have more open, liberal minds. We can't run away from that fact. And maybe that goes into the question of when the president says, I want a cadre judge, he's saying that I want a certain type, a certain brand of judge, meaning there are certain brands of judges who may or who may not agree with Peel as we know it. So I think South Africa was helped by the society in which Peel was birthed, the historical injustices, and that's why it was easy, for example, in South Africa, to easily allow certain constitutional petitions like on gender, sexuality, among other things. And if I remember well, I think it was Justice Albie Sachs who said that when you've come from a certain repressive environment, you tend not to want anybody to be repressed, and so when they come feeling and crying that they are being repressed, you tend to want to run to their rescue. The question that was raised by Vero, yes. The question that was raised by Vero and later on by the gentleman with the long name. Yeah, but I know he is the one. I seem to hear you saying, how do we go through one, we can't do much without the political will of the state. That even when a matter is being litigated upon, the political will of the state will either hamper or encourage that litigation. And sometimes the statements by the head of state will give you the dimension in which the state is thinking. But two, I think it's important for us to say that it takes a village. You know, we all need to put our hands into this matter in order for this matter to grow. When Sehad was doing the maternal health petition, you needed the media to keep barraging the public with cases of maternal health rights and how people have paid horrendous prices for poor access to maternal health. You need social media to be engineered in such a way that they keep targeting specific people to become aware. You need members of the public to be encouraged to write to their MPs, call them, send WhatsApp messages about this matter. You need to ensure that this matter does not leave the eye of the public. That is why in the case of George, what was his name? George, the man who was our brother who was killed in America, George Floyd, there was a huge uproar. I don't think it was easy, first of all, to get a juror who didn't know about George Floyd. Secondly, the media kept it in people's faces. Thirdly, all organizations were advocating. So advocacy cannot be ignored. So much so that by the time a judicial officer says not guilty, he had better have a really strong conscience to say, I refuse. Because everything around him is pushing him to realize that this matter is of such a high constitutional relevance that you cannot run away. Let me give you an example. When the AHA was passed, and we can pick lessons from the AHA. When the AHA was passed, you know the AHA? Huh? Anyone here who doesn't know the AHA? When it was passed, anybody who had a say in its passage or not was lambasted with emails from all over the world. There was serious mobilization. Okay? So when we go to court on these public interest litigation matters, we must lambast everybody who has something to say to join the struggle. You know, to join the struggle. When the Miriam Matembes, Honorable Dr. Miriam Matembe and others were pushing for an amendment in the penal code to make it a capital offense to commit defilement and rape, there was a huge push from all sectors of the public. So I think the political will and strategic intervention, like I proposed, when everybody is on the same side, like we put a pause on everything else we are doing and we say all NGOs, all government, all institutions, every lawyer, ULS, UCLF, the Muslim organization for human rights, all these organizations just come together for the cause. You don't leave Sehad on its own, but we all come together. I think that kind of concerted effort makes it very difficult because even the members of parliament begin to realize that if I am not seen to stand, let me tell you what happened in, and I know it's lunchtime, so I'll be brief. What happened with the Anti-Torture Act proposed prosecution, you know, in Makindye Court. If you are a relevant politician, you had to be there. You had to be there. There was that picture of the masses coming to attack us. And then there was a picture of one of the lawyers pushing Counsel Emma Chandia, our chair of in NetPL. There was a powerful photograph there that was taken. That strategic move, very critical in those. So the last question from my brother. I think, if I heard you correctly, it is up to us to prioritize. It's someone who is. It is up to us.
This is something else, not society.
Okay, thank you. It is up to us to make these issues a priority for the state. It is up to us. I'll give you an example. During one of the campaigns in 1996 for the presidency, I think candidate retired Colonel Kizza Besigye made the payment of graduated tax a hot issue. It was so hot such that the president had to scrap graduated tax within that campaign. So we must make it, we must find a way to organize ourselves. And I know many times NGOs separately or in conjunction with others involve key stakeholders in parliament. We've been engaging with the Greater North Parliamentary Forum regarding the Transitional Justice Bill and Policy, as well as the National Legal Aid Policy and its subsequent bill. We must engage the key stakeholders and make this thing an issue that whatever we talk about, all our campaigns and advocacy must focus on these issues. So you pick an issue, for example, environmental degradation, or the case we are doing as NetPL regarding land, I think in Masindi or somewhere, in Bugoma, and we make it a priority. That there is no individual. The president ULS is saying the same language, speaking the same language. There are meetings with the judiciary, there are meetings with members of parliament, there are songs being sung by the musicians board. You must be strategic for us to make it a priority. If it's not a priority, the state will not. And that is the experience I have had in certain fora, that once the state doesn't feel the pressure from the public, it will not consider this a matter. Look at what we did regarding bail. People were writing articles on bail. The discussions in the media were on bail. I was being called on NTV. Some of you were being called in other spaces. The ULS president met the president on bail. Everything was about bail. Until in one of his presidential addresses to us, I heard the president saying that I am happy that this thing is being discussed, but we shall not relent. Now, once he had, so that meant that our voices were being heard. So PIL must be not just a legal intervention, but we must strategize in all spaces for us to achieve what we need. Otherwise, the state will always find resources for other things, cars, opening up new districts, and so on, because other people are lobbying them in that direction. We must be able to do so. And lastly, I'm happy during the introduction of Dr. Zahara, it was mentioned that she belongs to a think tank. We need a think tank for NetPL. I think we act more and think less. This is my honest opinion. China and America, and I would like to recommend the book by Dr. Magara on think tank. China and America have hundreds, if not thousands, of think tanks. They think and contextualize what could happen 10 years from now. And as NetPL, as UCLF, we had started the think tank, Mr. CEO. I don't know how far it went. We need to just maybe pick lessons from what Zahara's organization is doing. that think tank. There was even the Kigo, I think there's a Kigo Trust something think tank. Huh? Yes, you need to sit like today. We should have something like this where we're just thinking, if we do it this way, what would happen? Envisage in 10 years from now, what kind of human beings are we dealing with? You know, we will not be dealing with millennials, we'll be dealing with generation, is it Z? Maybe there'll be now generation Z21. You know, we need to think, what kind of generation will that be? There is it's called a sitcom in America called Family Guy. Is it called Family Guy? It's sitcoms. They've been running for some. Picks an extract from those sitcoms and says, my goodness, the people who wrote this envisage phones that do everything. Envisage this. So we must invest a bit of, not a bit, we must dedicate time to think tanks, to think through some of the questions that Vero and others are asking. Otherwise, thank you so much for the opportunity to participate in this very important workshop. God bless.
All right, thank you very much, Doctor. That brings us to the close of our sessions this afternoon. We'll break off for lunch. We should be back here by 3 for the next session. It's coming to 2 now. We should be able to make it back by 3 for the last session for the afternoon. Thank you very much.
This is Joe. Say hi, Joe. Hi. He's a designer. A great one, I might add.
If you put down, if you tell you but if you have enough presence of mind, say
All right. All right. Can the people online hear us? Let's have an indication as to whether the people online can hear us. Francis, can you hear us?
Elton here, I can hear you loud and clear.
Francis?
I can hear you properly.
All right. Thank you very much. All right. Thank you very much, Elton and Sandra. We'll go into our second last session, which is brief. As you can see on the program that was shared, we'll have an assignment. We're going to create 4 groups, have an assignment which we shall discuss tomorrow. The assignment briefly is for us to pick one case, one decision that has come from our courts on the Human Rights Enforcement Act. Any decision of your choice. I will have 4 people per group. We're going to have 4 groups, 3 groups for the people online and 1 group for the people in-house. And in those groups, you will be required to pick a case, one case that has been filed on the Human Rights Enforcement Act. And then tomorrow, we will give each of the groups a chance to discuss how the courts have approached the enforcement of the provisions of the Human Rights Enforcement Act. So this is how the groups are going to be are going to be paired. This is how the groups are going to be constituted. In the first group, so in the first group, which we'll call group 1, we'll have Fred Biamukama Meire. That is for the first group. Then in the second group, we'll have Elton Mugabe, Joel Andrew, we'll have Elton Mugabe in the second group, Joe Andrew Wangwa, Timothy Atuhaire, and Timothy Atuhaire. That's in the second group. Then the third group, we'll have Grace Lamuno and Muhindo Harriet for the third group. Then in the fourth group, we'll have the members here. We'll have Council Susan, we'll have Lillian and CEO in the fourth group. Just pick any decision from our courts on the Human Rights Enforcement Act, and we'll have a discussion on how courts have enforced the decision, have enforced the Human Rights Enforcement Act. All right, so we'll then move to our fourth session. So the people online, you please you can use the platform to DM each other, and then you can see how to go about the assignment. We'll go into our fourth and our last session, which is on on due regard to substance and form in relation to pleadings in public interest litigation. And our facilitator for this session is like the previous one. He needs really no introduction. You have to be a foreigner not to know him. And for that case, an unserious foreigner. So our last session is going to be facilitated by Mr. Robert Kirunda, who is a lecturer at the School of Law at Makerere University, and also a partner at Chirunda and Wesige Advocates. He's seasoned in the practice, and especially in PL, and he will take us through the session on due regard to substance and form in relation to pleadings in PL. Mr. Chirunda, you're very welcome, and we are glad to have you with us this afternoon.
Good afternoon, ladies and gentlemen. Those here to the online audience, I wish you a very good afternoon. I hope that you're having a good day. I'm a bit unused to these virtual things. When I walk into a room, I assume there's an audience, very big audience. So now I'm here very intimidated by Lillian and our colleagues. So without much ado, very kind introduction, sir. But anyway, I was asked to speak about pleadings in public interest litigation, so I'm going to go straight to that and make some suggestions that I hope you will find useful. I have looked at the program. I have no doubt it's been a very productive day. I am going to try and share from some experiences of cases either I have handled, participated in, or read and reviewed for my own personal purposes. And I want to focus today on I want to urge all of us as practitioners to keep the 8 P's in public interest litigation front and center. There are 8 P's that we use at my office when we are preparing a suit, and they apply to the public interest litigation space especially. Some of them, in fact, apply uniquely. So I'm going to sort of briefly run through these and make some suggestions as to how they might relate to public interest litigation. Keep them front and center, and I think that you will not only have a good case, but you will argue a good case. It simplifies how you argue. It's helped. These principles have helped me as a practitioner. They have helped my colleagues as well. Number one, of course, is the parties. It sounds obvious, but the first P is the parties. Who is your client? But followed with that, it sounds obvious, but will your client, in public interest litigation, will your client sell to the court? Will your client appeal to the court? To use some colorful language, is your client sexy enough for the court to get the court's attention? So it goes beyond standing, but don't ignore the court. Standing is what used to be the traditional rule in locus standi, where we are saying, do you have injury? The law has sorted that one out now to say, you need not have injury directly for you to prove a case. But one experience we learned from a case, that an ongoing constitutional petition that I have handled. In fact, I'm going to give you 2 contradicting cases. ISA and UNAD, ISA being the Initiative for Socio-Economic Rights, UNAD being the Uganda National Association of the Deaf, wanted to launch a case against the Attorney General, challenging the lack of sign language interpreters at hospitals. That case, the petition was filed, it is pending before the courts. But when we were preparing that case, a question arose. And I remember it is someone very well regarded in public interest litigation who said to me, Robert, PIL should have a human face. Who is your victim? When we read, okay, ISA, yes, but why do they care? Why should the court care about ISA's views on public interest litigation? So we then went and found actual deaf people as petitioners. Now, what we intended to do in terms of strategy, which we eventually didn't do, was when the matter was going to come, I said to my client, I said, because when they gave me the instruction, I said, this case is so important, because ask yourself, how does a deaf mother say, I think my baby is in breach? Ladies would understand that very well, because there is no sign language interpreter at the hospital. So if she's having complications with her pregnancy, how would she say, I think the baby is not kicking anymore? It has been like this for the last 4 hours. She's probably sat at the hospital for 2 hours. So it's now 6 hours. And the condition is potentially getting worse. So you can see this is an obviously important case. When we were going to argue that case, what I had wanted to do was, just after doing appearances, to say, my lords, before we start, I have an application that I'd like to make before the court. I am requesting that we be allowed. The court provides a sign language interpreter, and if the court cannot find one, we're happy to provide one. Because my clients who are here today are entitled to follow the proceedings in their own case. Unfortunately, in our courts here, there is no sign, they can't hear what we are going to say. Think about the effect of that on the court. I would have made all my arguments by just that application. It would have mattered if I had said, my lord, the first 3 petitioners want to follow their case. So parties. I am also currently handling a matter where a client came to me and said, I want you to challenge this injustice, but I don't want to be known as the party who is challenging. At the same time, if an individual comes, they might bribe that individual because the people who are behind this injustice are very wealthy. So here is a good case. It is pretty straightforward. I've argued one like it and we got 100 million shillings in general damages. So I know it's a slam dunk. But my client doesn't want to be known as the person fighting. So in that case, what do you do? In that case, you find a company with a guarantee to be the party. So then you don't have the human face, but there's a good reason for it. So think through your parties, because these things will matter eventually. And you need to make sure that, because it will come back to say, why does this person care about this particular issue, which should be in the public interest? Pick a party who will make it easy for you to make out the public interest. We once wanted to file a matter. Some people came to me about a certain case, and I went to my colleague Zuma, I know, to be very well regarded in human rights, some of whom all of us here know. And they said, ever since we did the other case, people think we are opposition. I don't want them to keep saying a right is the one, this one, okay, a right has to be this one. So I think you find someone else. It was such an important case. Eventually, I think it never got filed because we couldn't find someone with the gravitas, with the credibility to match. Because also it will go to the CVs that you're attaching to your pleading. When we were arguing amicus in the Supreme Court, some of you might remember, they came and said, when we look at the CV of Oloko Nyango, I remember the Honorable Mwesigu Rukutana saying, my lords, when I see the CV of Professor Oloko Nyango, he's a professor of constitutionalism. He's not a professor of elections. And Chief Justice Katreve said, Honorable Rukuta, where do elections come from? He said in the Constitution. So what are you saying? But when we were preparing that application, I remember we sat and went through, okay, we know for sure that they might attack Professor Loko Nyango because they are saying he is partisan. Because in amicus, you must be neutral. And we wanted to clarify what neutrality actually means. So they came and said, this one, Oloko Nyango, he has attacked the government. Businje Kabumba is always on NBS abusing the government. Sylvia Tamala is Oloko Nyango's husband. I mean wife. Apologies. My sincere apologies. But then there was a fourth CV of Professor Christopher Mbazira. So all those 9 law dons that were on that application were carefully say government, there is a Mbazira whom you can't attack. If you attack Mbazira, there is a Nakai whom you can't attack. If you attack Nakai, there is a Ngabirano whom you can't attack. So think through it. It sounds mundane, but in public interest litigation, it will matter because if they attack the party you have put, your petition collapses. There is a NEMA case where they said if you didn't have a certificate of incorporation, therefore we have no knowledge that you are. And the other one, of course, is the question of how do I go? But I'm going to come back to that. So in terms of parties, have a human face, think through the connection because it might go to certain points of law. Sometimes you'll get a case where the client doesn't want to be known. This was the case, I believe, with the Environmental Action Network. And these are the cases that sort of brought PIL to where it is today. When the 10 cases were starting, now Justice Kakuru and Mr. Philip Karugaba, I believe their reasoning was, look, assuming one day a judge just awards punitive damages against us to shut us up, they can go and liquidate the company may guarantee if they want, but they can't attack us as individuals. They can't bankrupt us because Lee Kuan Yew used it in Singapore as a strategy to keep his opposition at bay. He just kept bringing defamation suits against his biggest opponent until the damages were so severe. There was nothing he could do about it. The guy ran to Malaysia, where he has lived all his life. So these things have consequences. The second is the provisions under which you are moving the court. Under what law? These are obvious things, but I raise them because of what I have seen. We know that in human rights, essentially you're going to go either under the Constitution or you're going to go under the Human Rights Enforcement Act. Or both, ordinarily. You could also find yourself in the law of torts. You could also find yourself, and the Human Rights Enforcement Act is a really good provision because it says, notwithstanding other causes of action. So I can combine human rights and death as a cause of action, for example. Or I can decide to file two separate cases because there is a particular point I want argued. I have been in meetings where we have to make the decision carefully as to which court. And clients always insist, I want to go to the Constitutional Court. Why? Because unfortunately, for many reasons, there's a trust deficit that has cropped into the High Court. People say the High Court is easily influenced, judges are shy and things like that. So they come and say, I want to go to the Constitutional Court. But do you have a question for interpretation? I was talking to Justice of the Constitutional Court the other day and I was saying to them, I was the Attorney General and we had interesting views, me and him. He had his views, I had mine on how the court is treating these matters, the question of whether there is a question of interpretation. So think through it very carefully, because the place where you go, the provisions and the place are related. The first P is parties, the second is provisions of the law, the third is the place. Place and provisions are related because if you want enforcement, go to the High Court. I am challenging the 30% rule on mortgages. And when I was before the court, they said, but how can you say that you want an order stopping the High Court from denying injunctions? I said, my lords, it is a consequence of what I am alleging as to be an assault on the Constitution. Yeah? So maybe you can combine enforcement and interpretation, but do you want to start in the Constitutional Court? Do you want to go to the High Court and then get referred? One view is that if the registrar should first vet, and right now, of course, the law doesn't allow it, but one suggestion has been to amend the rules to say, let the registrar first decide there is no question of interpretation, send to the High Court, let the High Court kick it up if it wants. But that complicates procedure. So thinking through the provisions and the place will lead you through questions like human rights enforcement versus constitutional litigation and what you're choosing to go where. But also, most of the cases we've seen have been on enforcement of economic, social, and cultural rights. There have rarely been cases on civil and political, the right to vote. When we did the amicus application, we entered straight into civil and political rights, the right to vote. As a result of that came the Professor Sempevo and Professor Juko application, in which we were saying, let's apply structural interdicts to civil and political rights. I'd like to suggest to you, ladies and gentlemen, and those online, that when you think through the provisions of the law, please think about them from another angle as well. The additional angle is, can we stretch the frontiers of the law beyond what has become obvious and routine? Are there economic cases we can argue in the context of public interest litigation? Take the example of BAT versus the Attorney General. I participated in that petition. I represented SEHAD, which joined to support the Attorney General in opposing the petition. BAT went to the Constitutional Court saying that the provisions of the Act were inconsistent with and in contravention of the Constitution. SEHAD joined the Attorney General to say no. When we were preparing the argument, I advanced the view that we need not argue that there is no violation. In fact, we should argue that, yes, you're right. Every provision you've cited offends the Constitution. But none of those provisions offend entrenched rights, Article 44 rights. But none of them, and therefore they are, the violations are demonstrably justifiable in a free and democratic society. Now, if you are pleading a response or you are pleading an application, the provisions you are relying on, you must understand them thoroughly. Because the argument, therefore, was no. How do you know these provisions are acceptable in the context of a demonstrably justifiable in a free and democratic society? I said no. There is a framework convention on tobacco control. It is ratified by 190 countries. I think it suffices to say this is a community, most of which countries are demonstrably free and democratic. This is the minimum standard. The treaty is the minimum standard. Therefore, every country is allowed to legislate provisions that are worse than treaty provisions. Now, you have to first prove that 190 countries are not free and democratic for you to assail that argument. So we pleaded that in the SEHAD application. You plead that such that they can understand. But also ability of the national objectives, because you will find human rights issues in national objectives that are not in chapter 4. So my argument is that you can actually plead the national objectives together with Article 45 to argue that there are issues here of enforcement and or interpretation. So look at the provisions and the place carefully. And try and go beyond the traditional rules. Don't forget about the supersedure rules, however, because they're important, especially with regard to pleadings. I was handling a case recently where there was a combination of death as a cause of action, negligence, conspiracy, human rights violation, every kind of thing. And one of the things I put in my defense was to say, this plain doesn't disclose the cause of action, or if it does, I am going to move the court to sever the causes of action. So that we deal with, pick one. In other words, I'm going to tell the plaintiff, pick your mountain and die, on which you want to die. You can't pick 10 mountains because you'll die on neither. Pick a mountain where I'm going to crucify you. And the civil procedure rules allow that. So maybe you want to defend a position. I know that our friends have filed, I think there's some interest in joining the petition to protect. You will need to think through the rules from the side of what should be the attorney general's position. So it helps to to anticipate the argument on the other side. What would it be? I think I am one of the most fortunate people to have argued public interest from a point where you're saying the AG is right. It's usually the AG is wrong. Okay? So think about that very carefully. And that leads us to the fourth P, which is your pleas. What are you pleading? Okay? I have some suggestions on your pleas. Number one, your cause of action must be clear and easy to see. Make it so obvious, because almost every human rights issue you will ever argue is political. I was saying to the justices of the Constitutional Court the other day that they are now using the excuse of there is no question for interpretation to avoid political cases. It is the phenomenon that I have described in one of my writings as manifesting what Professor Okonyang was called the subtle doctrine of the political question. The one that manifested in Sehad was the obvious one. This is a political issue, go away. There is a subtle one where the judge skirts around the merits. And I have accused the Constitutional Court to their hearing in their faces of doing that in cases they believe to have political undertones, and I have given them a quotation where an Indian judge has said every case that is constitutional is political in nature. Now, you may want to say this is not politics, it is the right to health. The Attorney General says, my friend, I have a budget of 44 trillion and I must borrow. Where do you want me to get money to do what you want? And I'm going to say some more about that. So make your cause of action so easy. Also think through carefully, who do you want to join to your suit, or who do you need as an ally? Okay? I am handling a constitutional petition where an NGO has challenged the PPP Act, the Public-Private Partnership Act, on human rights grounds. Fascinating, fascinating case. And so they wanted amicus. And the amici they have in mind are international. So I counseled them and said, you are going to the Constitutional Court of Uganda. Yes, I know Professor Philip Alston is very well regarded in international human rights and human rights globally because he keeps the company of people like Professor Lokonyango and so on and so forth. But you must think about the fact that you want to avoid the court viewing you as agents of imperialism. So my suggestion to you would be find some Ugandans who are credible to join this amicus application. That is because the court, believe it or not, the unwritten rule is that the courts will respond to a case depending on who has brought it. I say this with the greatest of respect. Our colleague, some of our, and let me not mention names because I think we can all spare ourselves some Twitter rants. Some of our colleagues I have good cases. But because they plead them a certain way, people have called me and said, that gentleman who is opposing that MTN IPO has a very good case, but he pleaded it the wrong way. So the courts are human, the judges are human. Now you can abuse them, you can dislike them. At the end of the day, when they say, I saw order, they have order. So don't kill a good case because you pleaded it badly. Think through who you want to join, who not to join. You see? I once handled a matter where they said, that one is an opposition character. Good cases are dying like that. Mbale was a good example. The age limit and so on. When is joined a good thing, when is it a bad thing? Think through these things when you're drawing your pleading. Sometimes we file cases that have 90 paragraphs. Sometimes it's inevitable. But do you need 90 paragraphs to say what you want to say? Or can you do it in 20? Why? Because, like I said, these justices and judges have a backlog. Make it easy. My standard at the office is what I call the coffee mug test. When I pick up pleadings, I want to pick up a cup of coffee. And by the time I put the mug down, I want the reading of this pleading to be so interesting that my coffee cools. But I also want it to be so captivating that by the time I'm done with this coffee, which I don't want to get cold, I've finished the document. It is that clear. Okay? So don't overwhelm the court. You might want to overwhelm opposing counsel. You may want to say, I want to give the Attorney General 200 affidavits. The courts have said the weight of evidence is not measured by its volume. Do you need 200 affidavits to make the same point? Or can you make it in 5? Maybe you're saying, I want a woman. In the ISA petition, we had affidavits that were traumatizing. A woman says, because she's deaf and she has a bit of a mental challenge, men were just using her. So what the mother did was to put a coil. Took her to hospital and they put a coil. She had no idea what was going on. Then she reached the point and said, but me, I want to have children. So what did she do? She got a fork, I think, if I remember correctly, and tried to remove. So we are saying, why is she getting to that point? Because she can't go and explain to a doctor that my mother doesn't want me to have children, but she thinks these men rape me, but I actually enjoy sexual intercourse. And I want to have a child. Now that evidence is good for its emotive value. But is it clear? Does it connect with the pleading in the petition? Did you plead a particular provision of the Constitution that connects that evidence to a case? Because you are telling a story and you want the court to understand your story with its emotions, with its passion. So you have a question of consistency. Also, what is a plea? You know, we call them pleadings, but you never stop to say, what is a plea? And why is it there? A pleading is not a newspaper. A pleading must connect to your cause of action. So if you're doing a petition, what I have found to be a useful style is to say, these are the parties, this is why they are petitioning, that standard provision. Your petitioners are believers in the rule of law, yada, 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 yada. And then the grounds. Your petitioners aver that article this, that this provision of this law is inconsistent with or in contravention of this article of the Constitution, insofar as this article, insofar as this article, insofar as. Your petitioners aver those grounds based on the following facts. Then I narrate in my 10, 12 paragraphs the facts consistently that give me basis. Now, those facts must tie with my affidavits. Every single one. So if you're going to have 50 affidavits, Make sure that every single one of them can lead you back to your plea in the petition. Remember, pleadings are storytelling exercise, but they're not newspapers. There must be a point in what you are saying. If you pick up a newspaper, on the left there is Kasese, on the right there is Bundibu, the Kasese floods, on the right there is the fight in Congo, in the middle there is who stole money, at the bottom there is a headmistress who has escaped with the kids. Next page, what do we see? Lockdown, COVID, then football. So when you try and say, what is the theme of this newspaper? Binunabiri. Consistent. Also, I have mentioned something here on amicus applications. Are they safe? Now let me go to the fifth P, which is, remember that you have to prove your pleas. Just because you plead doesn't mean you won't need evidence. So put every statement you put in your pleading, remember you will have to prove how it either violates or offends the human rights provisions of the Act. So pay attention, provide enough evidence, but don't overwhelm the court. If you plead it, you must prove it. That's the rule. If you plead it, you must prove it. The sixth P is precision. Be precise. We have a rule in our office against paragraphs that exceed 4 lines. One of the rules I've picked up in my adult education is that if you want to write a good document, a sentence should not exceed 2 words. There's some simple rules. Drafting. A sentence should not exceed 2 lines, rather. If you exceed in 2 lines, you're winding. Your documents will read clearer if your sentence is no more than. In fact, some people say, don't exceed 2 lines, preferably not more than 14 words. And there's science to this thing. Also, avoid the passive voice. Article 45 is offended because the Attorney General did not. The Attorney General offended Article 45 by failing to. You see the difference? Article 45 is offended because the Attorney General did not, versus the Attorney General offended Article 45 by failing to. One of them reads better, but also most often than not, when you avoid the passive voice, you end up with shorter sentences, and short sentences generally read better. Now, I've given the example of this lady and the fork and things like that, but how much emotion is good emotion? I missed Justice Chivita's presentation, but were he to be here or online, I would remind him of one of the cases that the first time I ever saw him in action in a court of law was many, many years ago when I was a law student. I think it was 2005, and the case was Susan Chigula versus the Attorney General. I will never, never forget that case in the Constitutional Court. Why I remember it is that they read an affidavit of what happened in the execution of convicts to prove that there was cruel, human degrading treatment. And by the time they were done reading that affidavit aloud, the whole court was quiet. Justice Chivita had to cross-examine Susan Chigula. It was quite a brilliant cross, I must say. Given the circumstances of the day, I think it was a masterful cross-examination. Emotion is good, but remember that those judges are human with personal experiences. So you might trigger emotions that swing them from one extreme to the other. If you come to attack, I was going to use a delicate example, but since this is being recorded, maybe I shouldn't. If you come to attack a land situation and a judge is on the opposite side of that argument. So all things in moderation. Be wise about the emotion and be precise. I wrote a letter once, and my lovely wife, who happens to be a lawyer, said to me, I said, you know, I've written this letter, but it's too long, I want to reduce it. So when she read the first 3 paragraphs, I said, Robert, it's not a letter. I said, what is it? You're quarreling. She said, no, you can't send this. You're quarreling. It's not a letter. I like to tease my good friend, Mr. David Kabanda. When they argued Sehad, unfortunately for him, Chief Justice Katurebe, in his judgment, said the petition had been clumsily drafted. Now, I have to give credit to my brother, because when he came to me to convince me to join Sehad versus Rene, he said, Omani, I think there's another petition we're working on. He said, Omani Robert, Ikinde say, it's because I don't want to go through that. I want to understand. And I give him, I will always respect David Kabanda for that, because he saw a criticism in a judgment against him, and he came and said, how can I make it better? And the petitions he's done after that are beautiful. So he learns from his experiences. How long is your pleading? I have talked about this before. The general rule, of course, is keep it short, simple, and sweet. Keep it short, simple, and sweet. Some of the people I respect the most and I've had the highest privilege of working with on constitutional petitions especially, my seniors, Peter Walubiri and Sawandera Ogalo. One time I went to Mr. Ogalo and said, give me a sample of a petition you drafted. I want to learn your drafting style. Not too long ago, by the way, I think about 2015, 2016. Because his petitions, when I read them, there was no paragraph longer than 3 lines. The Police Act, the Petition Telling the Police Act was one of them. It is just sweet to read that. So keep your pleadings simple, short, and sweet. That when they say, wank. The AG the other day where we were, he was saying, look, I have a problem with the well defense should I file? What are they saying? Now I've litigated against the Attorney General, the current Attorney General, in his capacity as a private practitioner, and now I'm yet to get an opportunity to litigate against him as the Attorney General. So I know that for a fact that I'm going to read pleadings from his firm. Short, simple, clear. So I'd urge us to keep it short, simple, and sweet. The 7th P, and yes, I am about to conclude, the 7th P is purpose. This is especially important in public interest litigation. Stop for a moment and ask yourself as you write this pleading, why are you doing this case? Why? Is it a personal fight? Is it really a matter of public interest? What do you aim to achieve? Also, will it matter in the end? What does this have to do with pleadings? A great deal. It influences what reliefs you ask for. I'll give you an inside story that I hope the people I'm going to talk about would not mind my sharing, because some of it might be privileged information. But when we were doing Professor Sempebo and Professor Jokovas as the Attorney General, we accused the Attorney General of this country of contempt of court in the Supreme Court. And we asked for a custodial order in the event he didn't comply. The strategy there was, we want to ask for 5 reliefs. The first 3 should be those reliefs that are so scandalous that the court will never give them to us. But the magic was in the last 2. It was Professor Mbazira who taught me that sometimes in public interest litigation, even what looks like a loss is a mighty victory. Because you climb a mountain one piece at a time, one step at a time. So you may think, do we need to plead all these things in one petition? Should we do a series of small continuous actions that will build momentum, which is what TIN did, the Environmental Action Network? purpose. Why are you doing this? The purpose of that application was to bring to the fore civil and political rights, to engender compliance with the amicus orders, that the orders that have been given as result of structural interdict. But also purpose will help us to demystify certain things about PIL, that is anti-government litigation. Again, at the engagement where I was, and I have written this in a paper where I was explaining the Professor Duko decision, I believe that PIL has done a really great thing by bringing structural interdicts into the main frame of civil liberties litigation, right? But now we need to go to the next level, which is to engender meaningful engagement doctrine. So if you look at the interdict that was granted in Sehad versus the Attorney General, it simply said, the Attorney General shall report to the court within 6 months on the steps taken. Full stop. If the purpose is to ensure that there's actual action, maybe you should go further and plead and say, we are requesting an interdict on the following terms. So that now your pleadings are clearer on why the interdict, how will it be realized? Because the AG was saying to the justices of the court, look, I have budget constraints where to fund insurance, health insurance alone, I need 4 trillion. I can't get 4 trillion in the national budget. And I told him, Mr. Attorney General, the answer to your challenge is meaningful engagement. When the civil procedure issues are done, now let the justices step down from that high bench where they sit, come down and say, how do you propose the state realizes these obligations? We will give you the answers to your question, because we know where your wastage is, where you can find the 4 trillion. When you think about purpose, it changes how you design your case theory and your litigation strategy. It also influences your prayers. At the end of the day, as I said, all human rights, all constitutional cases are political. They cost money. Now, my parting shot on that, on the 7th P is, be bold in what you ask. On reliefs, be bold in what you're asking for, but be wise. Many of us are either bold, but not very wise, or neither bold nor wise. Think through your prayers carefully, because your prayers are what the court will give you. Also, write your pleadings so well that a court is constrained to give you even what you didn't ask for. If you think through your pleadings, your petition, your notice of motion, your affidavits very carefully, you might even see the court saying, by the way, not only shall we, because if you read the Professor Lokonyango and 8 others' application, the court went beyond what we asked. In fact, the court found its own areas where there should be changes in the law that we hadn't even thought about. Or if we thought about, hadn't put in our pleadings. So you can move the court into a direction that even you didn't think about by simply having neat, clear pleadings. All these points lead us to the 8th P. And the 8th P is one of the most fundamental rules in private practice. When I was joining practice all those years ago, almost 16 years ago, I was told that the 6 cardinal rules of practice are prepare, 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 consult, consult, consult. The 8th P is prepare. Before you draft, have you read the most recent decisions on what you're trying to argue? Have you read what is happening around the world? Do you know why those cases succeeded or failed? Can you plead your case differently from them? Have you read the latest decisions of the court, read the minds of the justices and judges? Have you thought about which judge might hear this case? What do they like? What don't they like? I want to go to court and say there should be a no-fault divorce. But for the Muslims, divorce is a religious issue. Am I going to trigger unnecessary religious in nature like I have wanted for over 6 years now, to challenge the amendment that brought Islamic banking, because I believe it's an affront on the Constitution. Will it be pitched as Christians versus Muslims? Will it start jihad on the Christian? Are there Muslim justices in the Constitutional Court? How will they take my argument? How should I write it to avoid offense? What if I am appearing to argue? You realize that you might remove commas, full stops from your pleadings by thinking about these things. And the example I usually like to use in terms of thought and writing is that old expression, no man is an island. We all know what it means, right? My students may have heard this one before. No man is an island. If I put a comma after no, changes everything. Right? So think through as you prepare. Read what the judge said. Justice Kakuru was intrigued by our argument that in BAT versus the regime, Big Tobacco, when we argued, no, there's no violation. The offenses are justified. He was really intrigued. Sometimes. So the judgment brought that out. So if I'm arguing economic rights, is that my avenue where I should go? If I'm arguing unique maternal function, I want emotion but not to insult women. So I think, I prepare, I research. I go and sit and hear how judges think about a particular case. Then I say, oh, in my case, I won't make that mistake. The story said that in the Rebel MP's case, Justice Kanyehamba threw a joke. He was counsel in that case. In the Constitutional Court, he threw a joke at one of the justices who's in the Supreme Court now, and she was extremely offended. The court had to adjourn. Don't do that. There's another reason why you must prepare adequately. What if your case changes? I went to court last week and I had prepared for this application. Okay? The rules on setting aside the consent are clear. When we reached, the judge said, counsel for the respondent. I said, yes, my lord. I agree in the traditional rules this person doesn't fit, but I have read this consent again. Is it a judgment in law? Of course, what do you mean? Is it a judgment? Of course, it's a judgment in law. What do you mean? And we argued for over an hour with the judge. Do your pleadings anticipate? And this is the value of preparation. That if you have read widely around your case and they throw you on a maiden voyage you didn't think through, because you know the subject matter and you know the law, you will very quickly find your feet. So I would like to say, if I said nothing today, let me emphasize this. Please prepare. And by that I mean, think through your case, think through the parties, think through the things we're talking about before you draft your pleading and after you draft your pleading. A tip that has served me well in writing submissions is one I got from a current justice of the Constitutional Court when I was going to my 4th year in law school all those years ago. I asked him, my lord, he was at the High Court at the time, someone did me a favor and said, let me introduce you to a real life judge. Meet a judge. You can imagine an impressionable 4th year kid, like a kid in a candy store. I had all these questions. So I asked him, my lord, what is the secret to succeeding in private practice? He did not think, God bless his darling heart. He did not think, he didn't bat an eye. He said, prepare. I see lawyers every day. They come to my court, they have a very good case, but they are unprepared. Do you know what I do? I said, no, my lord, I don't. He said, I dismiss. I don't care how good your case is. If you're unprepared, I will dismiss it. I said, prepare. Because the clients know, they tell us, this one is good, but he's a thief. This one is good, but he's slow. This one is good, but he talks too much. This one is good, but he's careless. This one, the people think he's good, but he's a shark. Excuse the French. Prepare. And I can tell you from personal experience, judges value credibility. My good friend Nicholas Opio one time told me of a case that was sent in because a judge looked at it and told the parties, one of the parties, I think you should look for a lawyer called so and so. They handled a matter like this before me and they knew what to do. I'm not sure you'll make too much progress based on where you are. Prepare. Let your case theory be solid, let your strategy be clear, and be robust in what you're doing. Public interest litigation is inevitable in every society in the world. I think we've come a long way. I think it's going to become ever more urgent than before. Unfortunately, I see threats on the horizon that are going to complicate this space. But that is not what you invited me here for today, so I will pause that. I'll leave my thoughts at that on that matter. Some of them are internal within us as a fraternity. Some of them are external. But I urge that those of us who have the privilege, I call it a high privilege to argue a public interest case, should do our best to prepare adequate pleadings, a clear, warm, welcoming, loving, and delightful report to you. Thank you for your very kind attention. I hope that you found what I said useful.
All right. Thank you very much, Mr. Chironda, for those very powerful insights into pleadings, substance, and form. At this juncture, I will invite the participants, if any, 1 or 2 or 3 remarks on the presentation as you've heard it. Questions, remarks for Mr. Chironda.
Thank you very much, Council Chirunda, for the elaborate guidance in regards to pleadings under public interest litigation. I just wanted to know from you, what guidelines would someone use in the circumstances to decide and say, let's take up this matter for public interest litigation? Thank you.
All right. Lillian, do we have any hands online? All right. Any other questions in house? Okay, let's take this one, then we'll conclude.
Please allow me, out of no disrespect, please allow me to answer this while seated. I think it comes down to 2 simple questions. Is there a matter that truly qualifies as being in the public interest? How are we defining public interest? I have learned that many of the things that we bring up in the public interest will actually appear obvious. It's just that we never thought about them before. I could see the look on my dear friend's face when I said, how does a pregnant woman say, I think my baby is not kicking if she's deaf? You just never thought about it because you take it for granted. I never really paid a lot of attention to hearing disabilities until I was told my child might never hear a sound. I spent a lot of time doing commercial litigation. I could never have thought about, and wonder of wonders, that case came to me in the same month. I got those instructions maybe a month before my daughter was born. So 1 month later, a month and a half later, I'm in a hospital and the doctor is saying, your child might never hear a sound. Now, the case rings different. But at the same time, I must be careful to avoid my emotions from interfering. So I found that most matters that qualify as public interest cases will actually be obvious. It's just that we take so much for granted, we never realize the value of what we don't have. Many of us will not think twice about whether there's a ram when you're entering Hotel Africana. until you come for CLE and our brother Emma is struggling. You see, that many of us took it for granted that buildings must have lifts because we were born in the days of lifts. So when you talk about persons with disabilities, so for me the test is simple. Is there an inconvenience that affects a section of society? Can I point to a section and say, that is the public? Yeah. Because some things are just, and also whether take up or not. I mean, it's also going to come down to what I refer to as the choice between boldness and wisdom. Someone said to me, don't do the petition on Islamic banking because Muslims will never hire you again. Another one said, Muslims will kill you, you'll never step in Chiseka. So I sit down and said, but for me, this is a Christian mandate. You see? And you usually find that here is another test. To what extent must you go to convince people this is a public issue? If you have to insult people on Twitter to prove that you are doing a public good, there is a problem. That's just me. And that is the view to which I buy now. And of course, Twitter can't be the standard. I was talking to a young person who is at LDC now, and she said, no, for us who are taught that human rights advocacy, you must abuse if you have to get the point made. This morning I told Professor Mbazir, I said, no, that's not true. But she was insane. I said, this is your CLE product, NetPeed. Peter. I said, these are your products. They are telling us that they must abuse us to make a point. And Mr. Pidak said, So these are some of the, for me, I don't think that you'll find a clear manual, Mr. CEO, but I think that there are some rules that are almost second nature that will come to you and will make the question really simple. I have found that in all the matters I have argued, whether it is Professor Sempe Wanjoko versus the Attorney General, BAT versus the Attorney General, Isa versus the Attorney General, there was one that was almost like Fox or Doi, Judo Kelo versus the Attorney General. All these were cases that seemed, until they came to me, I never thought, by the way, incidentally, as in, it has always been on this, by the way, how come no one has challenged this before? That it is almost obvious that it is a question that needs to be addressed for the greater good of a section of our society. So those are the tests I use. Then, of course, I come down to wisdom. And I don't let sentiment calm me down from taking a position. Because fortune favors the bold, it has been said. Fortune favors the bold. So if I have to be bold, I will be bold. I will do something as long as I know my conscience is clear. And I have gone before justices and they've said to me, but Robert, I said, my Lord, that is the view I hold. Now, you might disagree with me, as is your right to do so. But that is the view that I hold. And here is the evidence. Make of it what you will. And I have won some of my fiercest critics that way. I've won them over. And yet because it's like daily argument. I sit on the Capital Gang. And my first 4 gangs were particularly challenging because of my dear friend Ofono Kondo. He's such a fantastic debater that he knows that if you can't beat the argument, attack the man. If you can't play the game, play the man. It's a rule in gambling. So he figured I had my issues, so he knew how to push certain buttons and I would lose my temper. Then when I figured, I said, this is simple. So I found a way around it. So is litigation, wisdom. So I would say, number 1, Mr. CEO, there's a measure of wisdom that is required in picking our cases. Number 2, it will usually be that cause that is practically obvious. That you look at it and say, incidentally, I had never thought about this. In fact, when they called me, they said, these women, they suffer in lines, they stand for hours, they call their names. I said, no, you're selling it the wrong way. Just go and ask, how does a pregnant woman say, I can't feel my baby? He said, incidentally, that the case is so simple to sell. You see? So I hope that helps. I have not found a clear set of guidelines, but I've just found principles that are fluid that I have applied. Also, consulting is a good thing. Talking to those who have been there. Every once in a while, when I have a PIL case, I call Professor Mbazira and say, Prof, I was thinking about this. And he tells me, if you go that way, you're going to make a mistake. The one time I ignored his advice, I regretted it. Well, I didn't ignore his advice. My client didn't take the advice. And we regretted it, both of us. Again, going back to purpose, what do you want to achieve? Because sometimes you could end up with a precedent that will make things worse than they were before you filed. Purpose. So, as Simon Sinek would say, start with why. Why is this case? A friend of mine who used to be internal auditor, Standard and Chartered, said to me, Robert, when I am auditing this bank, I ask the question why 7 times. By the time I get the 7th answer, I know what the real problem is. So maybe that's another useful way to do it. Why is this a public interest case? Why should we, why does that, why? But High Court, why High Court? Because we want, it is quick. But why is it quick? Because, but why is the court slow? 7 whys. Then if you are still convinced to do the case, fine. Those for me would be the yardsticks I would use if I was choosing whether to file a matter or not. Will it do a public good or make it worse? If you go to shut down the anti-corruption court in a constitutional petition, are you doing a public service or a public injustice? You see, sometimes we want to file cases that are scandalous or that will scandalize the court. There was a man in South Africa who sued the Constitutional Court. He sued the justices of the Constitutional Court of South Africa. And he took the case to which court? Constitutional Court. He sued all of them, meaning you're not saying, no, let Justice Kakuru step aside, let Justice Chiriamure step aside, let Justice Chibedi step aside. For him, he sued all of them. And they had him and gave him judgment. All things in moderation. I hope that was a helpful answer to your question. Thank you.
All right. Thank you very much, Mr. Chairman. Do you have any questions there? All right. So okay. All right.
Thank you very much, Council, for the response. We are legal aid service providers. We have been told by some actors that we need probably to have a lot of finances set aside for a particular cause in regards to public interest litigation. You've had the opportunity to litigate some of these cases. Have you had a very big budget? Okay, if in any case, how much could we need to probably take legal aid service providers?
I would like to add on CEO's question because it's like he read my notes. For me, my question was that are there any probably ways that you can suggest to us that we can use to work within the minimal resources that we have? Yes, the budget might be big, but are there ways that you can suggest to us, maybe, so that we can work within the minimum resources available? Thank you.
I am going to start with maybe the last question, and I'll come to the first one. And permit me to use a passage of scripture. In the book of Hebrews, the Bible says, since we are surrounded by such a cloud of witnesses, let us run the race set before us with perseverance. I have seen that legal aid service providers don't maximize the goodwill they have. Ordinarily, if a client comes to me and says, file this case, in some cases they have. I'll give you my personal experience. Isaac comes to me and says, Robert, we have a case. We think you're the perfect person for this case, but we are concerned that you are very expensive. This is how much we can afford. And they put the figure to me. Say, the farthest we can go is so much. Constitutional petition. The truth of the matter is that at that time, that was maybe 30% of what I would have billed for that petition. But because for me, and this is before my daughter is born, because for me the question was so intriguing, how come nobody has ever thought about persons with disabilities and hospitals? By the way, what happens in the courts? I wanted to do the case, and I literally begged them to let me do the case. If I had given them the figure for budgeting purposes, they would have saved 30% of that budget by me agreeing to give them a haircut because I believe in the case. Cloud of great witnesses. Goodwill. People like to associate with change, transformation, progress, and things like that. Which takes me to, so one of the ways is to maximize the goodwill that you have. And I have seen this even with the most senior lawyers in this town. I know that I have worked closely, and I say this because I know they wouldn't mind. I have worked closely with Mr. Peter Walubiri, who is really, in constitutional matters, that is the Holy Grail. Peter Walubiri, Wandera Ogalo, and so on. Even I am in awe every time we work together on a case. And I am happy to do all the donkey work because I learn. So you can imagine putting the three of us together to say, argue this case. Maybe it's going to cost too much. But I have also learned that if you send people who know them well to say, there is this matter, sometimes they'll say, I need some level of commitment. We can always discuss the figure, depending on how important the case is. So that's the first thing I'll say. Second thing is, ask yourself why. It really, and which takes me to the first question, because they are related, on budget. It comes down to strategy. And for me, the first question on strategy is why? What are you budgeting these things for? A trend in these public interest cases is to say we need a big media appearance. But a press conference costs money. If you want a live stream, it costs a different budget. If you want a story in the newspaper, that's another matter. I have had the privilege of having goodwill with online reporters who are credible, whom I can say, if I wrote a story, would you run it? Of course, but same. If I tell them, come and cover the event, they'll charge me money. If I write the story because they trust that I will write a good piece, which will get them mileage, they will publish it, sometimes for free, because they want my name. So if UCLF goes to Dr. Rueza and says, we know you can get a slot on Spectrum, would you please mind getting a slot to speak about this issue? I've done it for people who have called me and said, we want to get media attention, but we can't. And I have called the producer of Spectrum and called in a favor and said, because when they need me in a crisis and they can't find a person to appear on the show, I go. That is what I mean by maximizing goodwill. So you may have had a budget for media, and I have saved you 5 million by calling a producer. But you would need to know that I can do that. Or
I would need to know the timing. And I'm not saying that it is automatic, it will happen. I'm just saying that these are some of the avenues. Sometimes you can identify partners, which goes to who do you add, who do you remove from your litigation. And these partners will have the budget. You see the acting editorial mirror, but you can sue me and I'll defend, or you can come and work together on streamlining what needs to be done. Away from the noise. Your call. Must it be a fight? That's another way to, and then you'll find that they'll tell you, okay, let us agree. You're going to change here, 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 but even me, I need money for this. Collaborate. Don't make enemies. You see, now, how much do you need? The honest truth is, I'll tell you that every case is different. In some cases, your budget is determined by the size of the enemy. When you are fighting big tobacco, you're fighting deep pockets. You need a budget. And that budget will not be small. Why? Because we argued 14 grounds in that petition, and none of them was trivial. The volumes, we had to color code. My Lord, volume 3 of the yellow binders. My Lord, volume 4 of the blue ones. Because I think blue was pleadings, yellow was evidence, green was authorities. That costs money. If the case is complex, you will need a budget. Why? Because you're asking me to do what is more than what I would do in my sleep. And I'm going to tell you, it's not because I want UCLF to pay me a wage. It is because of the opportunity cost that I have to kill my client's work for a week to do this case right. But one which I've argued before, I can write pleadings in 3 hours. My fee to UCLF will be different. But if I have to finish the pleadings, go for stakeholder engagement, then go for that press conference, then there's Capital Gang on Saturday, then there's Spectrum on Friday. Now that is taking more time than I would ordinarily give for free or at a discount. So I'll come to you and say, listen, I am going to charge you money, but this is why, and this is how I'm arriving at my figure. If I look at my diary, the matters I must delegate, and sometimes I'm charging you money so I can pay other lawyers to do me a favor. I can say without fear of contradiction, I have benefited from people like my brother Arthur Yoretire. When I have called him and said, I need to do me a favor, I know that your services cost time, I will pay for your services, but please represent this client for free to them. So I tell the other party, I'm going to get you a lawyer for free, but I'm going to get you someone I trust, you won't be misled. And I have to get money from my pocket and pay my brother Arthur because he also has a family to feed. But the other person was going to make litigation complicated because I couldn't afford a lawyer. There are cases where I have referred people to UCLF, so even I know that UCLF is doing an excellent job. So it comes down to how much you need will vary from case to case. So when you're thinking through your case strategy, your litigation strategy, and which partners to bring on board, and which case to file, you may want to think about how much will this reasonably cost. Then you can tell some of us who have litigated before and will tell you, you can still get publicity without a live feed. Maybe you want to call so-and-so or so-and-so, or I know that that NGO, the other NGO, the other international partner is doing something like that. Maybe you want to partner with them and let them bear some of the burden, which goes back to consult. Prepare. I hope both of you find that a bit useful. And thank you for your time.
All right, thank you very much, Mr. Chirunda. We have a question online from Timothy Atire. He's asking, kindly outline the principal resource and precedent material that would aid appeal litigator. If I may repeat, the principal resource and precedent materials that would aid the appeal litigator. And secondly, the best appeal reports and leading authors, publications, or journals.
I think this is a question that should best be addressed by Professor Mbazira tomorrow. I'm going to suggest that, Mr. Twaire, you raise the question to Professor Mbazira, because I don't know anyone in Uganda today who is best suited to answer this question. And since he's on the lineup, I think he'll give you a much richer answer than I can. But I will venture one or two suggestions on best peer reports and authors and journals. Professor Mbazira's entire PhD is a starting point. And he has a book on litigating economic and cultural rights. He has written on structural interdicts. He is the first author I would recommend. Find his work. It's extensive. Read it. The second author and really important book that I personally go to from time to time when I am preparing for public interest litigation is Professor Lokonyango has a book on public interest litigation in East Africa. It's a whole book. It's a very, very good book. It has a chapter on when courts do politics and things like that, the challenges of litigation in PIL in Tanzania. And he really has traversed 50 years of public interest litigation in East Africa, how it arose, what the challenges have been, where we need to go. That's a book that I would recommend very strongly. There used to be a compilation of environmental cases, which had a good collection of, I used to have it when I was a law student, but again, this was before Lillian was born. So it may be a bit antiquated. I am not sure that there is I'm not aware of a particular report that covers PIL. I would think, though, that you may want to get in touch with NetPIL and PILAC, because I think given the research projects that have been done around this, that would be a good place to visit. And they are here, they can probably provide a list. But the principal resource, one of the most vital resources that you must, as I said to my students earlier today, is Yuli is your friend. Almost every case that we argue in the High Court now is uploaded in a matter of days or at most weeks from the time the decision comes out. It turns out that now Twitter is a good place to follow what is happening. I don't think it should be that way, but who am I? What do I know? I have been called a Nico Mpumpu on Twitter, so maybe there might be some value in some of that. What one of my clients calls razzmatazz. No, I certainly don't think I'm a Nico Mpumpu. Neither do I think that we should litigate on Twitter, but I stay on Twitter because it's one of the fastest ways to get news of what is happening and to learn. So when you're on Twitter, one of the tricks is, who do you follow? Okay, so I follow centers like at Harvard, Yale, Stanford, that I know are doing interesting things. But like I said, I think this is a question that Professor Mbazira, in fact, I suspect this might be his entire presentation. So I hope that Mr. Twaire is able to join, and if he is, that he or one of us will ask this question tomorrow.
At Twaire, at NetPIL, we have getting various rights, but also one of the other tricks that might help is if you know of a case that is a bit similar, or you would think is a good precedent on what you intend to litigate, you can just match up to court. Most of this information is public record. Just match up to the court, speak to a clerk, and they'll be able to provide you with a file or for a case that you intend to litigate. You usually find everything from the first pleadings, maybe to what was amended, up to the judgment. So sometimes it's a trick that can help, especially if what you're litigating is something similar to what has already been litigated. Yeah. Then also, if I may add for to our two friends from UCLF on costs. And one thing that could also help is partnerships. Don't do PIL alone, like Mr. Chirunda has said, in part of preparation. If to the extent that is practical, please don't do PIL alone. Consult, build synergies as you conceptualize these matters. It helps in really reducing the cost when you move alone. And also, it's not entirely accurate that it's costly. It should be costly if the matter is novel and complex, but if known as such, is a lot to do with strategy, and also part of strategy is how you manage costs. Get partners as you go along who have done this a bit longer. They'll be able to guide you on how you save money here and there as you go along. I see no other questions online. We will pause it here for today. I will not use the word end because we will end tomorrow. We will only pause here for today, and we will be able to carry on tomorrow. So on that very note, ladies and gentlemen, allow me to thank you for your participation today and for being with us since morning to this time. We'd also like to thank the various presenters that we've had today, from the Honorable Justice Mike Chibita to Dr. Zahara Nampeo. But Chirunda, we are really grateful for the information that we received from you today. And to all the advocates, the participants, for the time that you put into to get this knowledge. We hope that it will serve you in your work. We'll pause here. Allow me wish you a very nice evening, and we'll resume tomorrow. Thank you.